With respect to that legislative, I'm sorry, what was the next word?
Supremacy.
Legislative supremacy. Are you suggesting that legislated rules can trump the imperatives of the Fourth Amendment?
Well, I think the biggest reason that we consider the legislative branch more effective than the judiciary is because oftentimes the judiciary has to wait for decisions to come to them. For example,
my question is whether regardless of the potential advantages or benefits of legislated rules can trump the Fourth Amendment.
That's not exactly what we're saying. We're saying that the legislative branch can interpret the Fourth Amendment in different ways, and they provide the guidelines for the searches and seizures.
Which interpretations would be subject to judicial review?
Law professor Oren Kerr, like we stated, says that the legislative branch would be better than the judicial branch and make. I don't completely agree with him, but he states that they would be better because the judicial branch the Supreme Court has trouble keeping up with the new technological issues, and as my colleague Neil said, they have to wait for the cases to come to them, whereas...
Regardless of what's better, has not the United States Supreme Court put to rest since 1803 the proposition that the courts have the power of judicial review of the constitutionality of governmental action?
and we're not denying that judicial review is obviously still in place. However, we feel that the first interpretation, you could say, for example, of text messages should be taken by the legislative branch. For example, we could take a look at wiretapping. In terms of wiretapping, 1870 was the first wiretaps, and in the Katz v. United States decision by the Supreme Court was the first court to make solid regulation on this. However, the legislative branch quickly supplanted that in the Wiretap Act, and that is what is now used in terms of wiretapping.
Let me throw a hypothetical that I've used a couple of times today. Suppose that the four of you are conspiring to traffic in drugs, and you and I, as law enforcement, get a warrant to look at your computer and looking for financial records of the trafficking enterprise, and I come across pornographic child pornography. Can you be prosecuted for that?
Here we can look at the compelling public interest standard. Child pornography is something that,
Yeah,
even though it's something that
isn't. Listen to my question, though. I've got a warrant to look at the financial information on your computer, but it does not include anything else but that. Can you be prosecuted for that? Does that invoke the Fourth Amendment? And if so, why and how?
I believe you can be prosecuted because of the compelling public interest standard, which states that the public does not want a society filled with the victimizing of child pornography. And although you don't have a warrant that requires you to look at this aspect of the computer, I believe that because it is something that is so victimizing and so dehumanizing to the people, that it would be allowed to be prosecuted.
Okay, but what about in terms of the Fourth Amendment?
Also, in U.S. v. Boucher 2006, the defendant had found child pornography in his home, and they knew that there was some on his computer too, and they were going to charge him with that as well. And they did not have a warrant and he had an encryption password on his computer, and he was forced to give that up. The Supreme Court ruled in 2006 that he had to give it up so they could search his computer, and they did find child pornography, and he was charged.
With respect to data mining in general, under what circumstances does the Fourth Amendment require the issuance of a warrant pursuant to probable cause as a precondition to searching the database, and under what circumstances does it not?
I'm sorry, could you repeat the question?
Yeah. When does the Fourth Amendment require the issuance of a search warrant supported by probable cause as a precondition to mining a database, and under what circumstances does the Fourth Amendment not require that?
Well, I think for that we have to look at the actual social contract, like a locking social contract. The citizens would be protected by protection of probable cause, versus someone who is not a citizen would be under reasonableness instead. Similar with minors and criminals.
There are many other instances where the national government does not need a warrant. There's the third-party doctrine established in the 1976 case U.S. v. Miller, where they requested bank records from a defendant, and he said that he had an expectation of privacy over his bank records. The court ruled that he did not. So the third-party doctrine states that the government can request records such as IP addresses or pen registers from a private business.
All right, so a search warrant supported by probable cause to believe a crime has been committed is a precondition to mining a database consisting of information in which people have a reasonable expectation of privacy. Is that correct?
Yes, the Ninth District Court of Appeals actually decided on February 18th of 2010 that they need a warrant only in reasonable expectations of privacy. But the 8th, 10th, and 6th Circuit Courts have made differing decisions on this, and therefore we need this decision to be made in the Supreme Court in order to help somewhat like settle the differences between the circuit courts.
I think we all agree that the Constitution is a living document, and that we have a right to privacy in a person, place, and things and papers. Should the Constitution now be interpreted to include an iPhone as papers, because the founders clearly couldn't foresee that that an iPhone is nothing more than electronic writing, although I'm not using an iPad today.
I do believe so, because if you think of it, if anything can be printed on paper, a police officer needs a search warrant to see it, especially if it's in the private hands of the person. So therefore, just because it's intangible doesn't mean that it excludes this from being considered a paper.
In addition, I think Kelo v. U.S., I think it stated that if you use technology to find out anything about a person that would have not been formerly, before technology, discoverable without a warrant, then that would be an unconstitutional search.